Welcome, students. This week we are going to get into Chapter 6. This is our study on criminal law. This has been through almost every class that I've taught this. This has been everyone's favorite section. At the end of the term, you get a chance to let me know if it's yours too. We're going to get into it with the PowerPoint uh, in here in a couple of seconds, but I first want to do a couple of little announcements. I've extended the case study number 2 out a week due to just feeling under the weather for a few days. I didn't get everything graded and all the comments and everything that I wanted to. So I want to try to spend some time grading those over the next couple of days so that you have some good feedback on what you need to fix on that. And really and truly, it's the same mistakes that I normally see with the first case study that I'm seeing again. So it's kind of expected what I'm seeing there. So not any major issues, just some of those APA things that I talked about when I first started talking about the case studies that are going on. But you'll be able to see that, and I'll get into that in a later video a little bit more about a couple of the issues that were arising there. A real quick way of saying it's just go back and watch the video on APA and reference whatever materials you have on it. It would be very helpful for you going forward with the case studies to keep from losing a lot of points on those. Also, this gets us back on track with this week. Last week was kind of that off week. We didn't have any new material we were really looking at. You had a little bit of space in between your modules and your chapters. So this will get us back on track and get us going up and getting ready for the midterm. All right, so without anything further, I'm going to go ahead and share out this PowerPoint with you. Get it going. All right, so we are in Chapter 6 this week. We're talking about business law. We're going to look at the nature of crimes. We'll talk about some of the white-collar crimes, what crimes against businesses are, some of those defenses that you have to those. And we'll go a little bit about criminal procedure, not exactly in that order, but we'll talk about those items. First thing that we really need to kind of get an idea about is what criminal law involves. Now, it's the definition really encompasses everything about it that you need to know from that first step into criminal law, is that it's a law that's designed to maintain order in society. When we talked about what law was, it was about maintaining that order. Criminal law takes it a little bit further by establishing what that conduct is, what the punishments for violating that conduct would be, so that we kind of have an idea of where we need to be as far as the law goes, whether it's as individuals or as businesses. We know what we're supposed to do, what the law says we can do, and what will happen when we do not follow the law to that. When we think of what a crime is, for criminal law to come into place, we're going to need a crime to happen. So with a crime, it is an act or an omission of something that the law says we cannot do. Law says there are certain things we have to do, especially when it comes to businesses and establishing a business and getting that set up. Well, a lot of that has to do with the law says we have to do this, we have to file this paperwork, we have to follow these procedures. Certain industries have specific laws to those industries that have to be followed, or criminal process and criminal procedure can be the result of it. A criminal charge can happen if you're not following that. The basic elements of what we look at for a crime to have taken place are two real simple elements. They are this actus reus and the mens rea. Mens rea, most people have heard of. It's the criminal intent or that guilty mind. It's when you plan out the crime, when there was some type of intent. You meant to do what you did. You meant to bring that harm to society, to an individual, whatever it was. And the actus reus is the act that you intended to do that caused the wrong. All right, that wrongful act is going to be your actus reus. It's criminal mind and criminal act, or what they basically they define as. And when we look at those, the types of mental fault that take you back to that mens rea that you can look at with uh, breaks down into three kind of major groups. The two that you run into the most are subjective fault and objective fault. Subjective is it's just, you knew you were doing it. You did it as in a reckless way. You were purposeful in it. If we think about the crime of murder, for it to be a capital offense, there has to be that premeditation or a purpose in how the person is acting and the decision they make to commit the crime. Well, same thing happens with embezzlement and larceny in the business setting. There is a purposeful intent to steal money, to embezzle money, to hold back funds in an embezzlement case that are earmarked for something else, but you hold them back for yourself. Larceny, that same way of, stealing from a business and those type of things. Those are knowingly you're doing that. Ones that are objective, they carry more of it's a negligent act, not so much an intentional, but a negligent act. Are things like careless driving, issuing bad checks, can be considered that also. Uh, Driving under the influence, especially if it causes harm to someone, those would fit into that definition. Now, where we can get confused, and I don't want you to get confused here, but where you can get confused is that with objective, you see the act, but where's the mental state, that mental fault? Well, the mental fault in this is that you were doing something negligent. You made a decision to do something that you probably knew wasn't right. Careless driving, that could be texting and driving. You make a decision to text and drive, and that results in a careless driving too fast. You make a decision to put your foot on the gas and go past that 45 or that 55 or whatever the speed limit may be. Same way with issuing bad checks. They are negligent in the way that they are looked at, but you still have those elements. You have a act that's there, and then the mental decision to act in such a careless way as to cause these things to happen. The last one, and this one is really and truly does apply to businesses, probably more than it does individuals, the liability without fault issues. It doesn't require fault of an individual with these. It is the sale of alcohol to a minor, the sale of adulterated food, the type of things that are causing harm in what you do. There's a law that specifically says not to do it. We have laws if someone is running a convenience store or any store that sells alcohol, a bar, any of those type of establishments. They have to make sure that they are getting the proper ID from the individuals making these purchases. You could add in sell of tobacco, sell of firearms, any of those things you wanted to add in to the sale of a minor. The sale of adulterated food, that's knowingly selling food that may have been out of date or may have a contamination in it. We see food recalls all the time. We were just discussing in our household just a couple of days ago about the large recall of bagged broccoli, florets that Walmart had to go through because there were contaminants in a whole lot of their, and when I say lot, the lot numbers, a whole lot of their broccoli that they buy from one of their suppliers. And a lot of times it's not necessarily the corporation that may get in trouble that originally set this up, it was a supplier, but because they maybe didn't act as soon as they should have, there'll be an issue there. Pardon me. There'll be an issue there that causes fault to uh, be out there, but it doesn't necessarily rest with them. But because they were selling it, they would then be charged with that issue. Crimes can be classified into felonies and misdemeanors in most states. Felonies are your most serious crimes. In the state of Florida, we have three levels of felonies. You have misdemeanors that also have a couple of different levels to them. Those are lesser crimes. Felonies normally would be what carries a prison sentence and stiffer penalties beyond that, where a misdemeanor may be a small fine, time spent in the county jail, those type of things. Misdemeanors can be a suspension of a license, could be in a business setting, suspension of a business license. Not so much like a driver's license with an individual, but a business license. You could be told that you cannot sell alcohol. If someone is convicted of selling alcohol to a minor, they stand the chance of losing their liquor license, which allows them to sell alcohol in their establishments. Vicarious liability is liability that is imposed for acts of employees if the employer directed, participate in, or approve the acts. We see this in larger corporations where, and you will in smaller ones too, but it mainly comes in your larger corporations where the individuals working for the corporation will do something that violates the law, and there will be a investigation done that will then show that their employer knew about it, maybe even directed them to it, participated in some way, but by their inaction, they basically approved of the act. And that is where they come into the issue with vicarious liability in businesses. Criminal procedure will differ as we go through, and we've talked about how the court system and how our judicial system is set up, but each state has their own procedures. The federal government has its own procedures that are set up for initiating and coordinating criminal prosecutions and how that is handled. Depending on the level of offense and what type of crime it is, you can have what is called a grand jury being convened. We've talked about that previously. We kind of brushed over a little bit previously, but the grand jury is convened for instances where it could be an infamous crime, one that the sheer publicity around the crime would require that the government would get some type of extra step in there. And that's what a grand jury is, that extra step where they lay out the bones of their case, and a group of citizens sitting on a grand jury would tell them whether or not that case should proceed, or what is called handing down an indictment. They would give that indictment, indict the person for the crime. It's not a call of guilt or innocence at this point. It's just saying that the state has a case that they should move forward with. Those are part of the how the prosecutions are set up in a lot of different states. The federal government does something similar. Part of our criminal procedure and our protections within criminal procedure as either individual citizens or as businesses, which are treated as individuals in these cases, they come from the first 10 amendments to the Constitution. That Bill of Rights, that protection we have, our Bill of Protections from the government and how we are protected from the government interfering in our lives, also gives us defenses and rights as far as being an accused party. If we're an individual or if we're a business and we're an accused party, those rights do kind of go hand in hand. There may be some minor differences because it's a difference in what the party is, but it still would be the right and protection against search and seizures, that Fourth Amendment, the right to not incriminate yourself, the speedy trial, those type of things. So there are, and we'll get into those in a few slides, but those rights are there for all of us treated as individuals within the court system. So if someone is subject to custodial interrogation, they have been placed under arrest, they are given their Miranda rights. Now, we've probably touched on these, but just to kind of go over it again, the Miranda rights, hopefully you've never heard them being read to you, but you've probably heard them on TV or in some instance like that. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you by the state at the cost of the state. That is an important part of that is that if you can't afford it, the state pays for that attorney. It's that public defender that they give to those who cannot afford to purchase their own defense. Then you're asked, do you understand these rights? Miranda came about, Miranda v. Arizona. A gentleman's last name was Miranda, was arrested, was not made fully aware of his rights. There was some confession and some other things that happened. And once it made it to the Supreme Court, they looked at it, they realized that this person did not have a full grasp of what the rights were. And so it was kind of put into place that these Miranda rights will be read when someone is being asked to speak to law enforcement. You have rights that protect you from, saying something that could cause you to be put in a light that is not quite where you want to be. A quick breakdown, and we'll get into them. We'll spend a little bit more time with these, but a quick breakdown of your amendments and how those protections extend to us as individuals. And keep in mind, it's not just individuals, but as a business, if we're having to, as a business, defend our actions. The Fourth Amendment, of course, is unreasonable search or seizure. The way that a warrant affidavit is given out, those type of things are covered in that Fourth Amendment. The Fifth Amendment is that due process, the right to indictment by a grand jury for capital crimes or infamous crimes. It's applied to the states. That one particularly goes to the states based upon the 14th Amendment. The 14th Amendment makes sure that the rights we're given are the states required to follow those. The freedom from double jeopardy. Double jeopardy we'll talk about here in just a second. We'll also talk about it in the next module when we discuss how it doesn't apply to our civil cases, and the freedom from self-incrimination. So the most common way anybody hears about the Fifth, and most people of my generation learned what the Fifth Amendment was during the investigations into the Iran-Contra scandal. Now, most of you that'll be watching this, you're way too young to even have a clue what that is. You may have heard your parents talk about it, or maybe in a history class you've read about it, but it was a major investigation into the Reagan administration and a deal for hostages to be released and arms being given to a group and some other back channel dealings that were done to kind of, and it kind of circumvented the way that things were supposed to be done according to the legal means of how our government is supposed to act. And a lot of the defendants in that, when they were, before they were even criminal defendants, when they were just called to testify in front of Congress, they would say they would plead the Fifth. In other words, they were claiming their right to not say anything that would cause them to be to incriminate themselves in their statements. So in other words, if you can only answer a question by in the answer saying you're guilty or you could possibly be part of a crime, then you have the right to not say anything. Part of that Miranda right, that right to remain silent, comes from the Fifth Amendment, where you have the right against self-incrimination. The Sixth Amendment is where we get the other part of the Miranda rights. And that's the right to competent counsel. You have the right to an attorney. Those two amendments carry everything that you need from the Miranda rights, because you can build everything else inside those amendments from those two. The right to a speedy and public trial by a jury. The right to be informed of accusations, the right to confront your witnesses, to present witnesses in your defense, and of course, that right to competent counsel are part of the Sixth Amendment. What goes into that, and we'll spend more time talking about it, but all those, and you have to keep in mind that these are rights that you, just like any right, you have the right to free speech. Doesn't mean you always have to say something. You can not say anything and just not exercise that right. The same thing applies to the rights that we'll talk about when we go through these amendments. Uh, you do not have to exercise each of these. There are choices that you can make as far as a defendant in a criminal trial. And then the eighth is freedom from excessive bail and the cruel and unusual punishment. Almost, I won't try to put a number on it, but majority of lawsuits that come out of correctional institutions and anything in the correctional side of law enforcement is going to be cruel and unusual punishment types of lawsuits. Many of those do not fit the definition of cruel and unusual punishment that the courts have set up. But that is, we are protected from that based upon the Constitution. So the Fourth Amendment reads, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons and things to be seized. A lot said in that, in just those few words. A lot is said within that about how you're protected against searches, against seizures, how your person and your property is protected against anyone coming on it and just off of a whim searching for stuff. If you've watched any type of TV show that was Hollywood's idea of what law enforcement does and how they conduct themselves, the Fourth Amendment is violated on almost every episode in some way, fashion, or form. They will violate the Fourth Amendment. Normally, some type of unreasonable search or using tactics that the courts would not allow. Of course, Hollywood they would because it makes for good TV. But tactics that the courts will not allow that specifically violate this Fourth Amendment. So it's important to keep in mind what those are. Look at it a little bit more. It prohibits illegal searches and seizures. Now, illegal searches and seizures. So what's a legal search? One that carries two ways of looking at it that will cause it to be legal. The first and the foremost way is law enforcement has written up an affidavit and given it to the judicial branch, and the judicial branch will sign off on that affidavit saying that, and it's an affidavit is a sworn complaint or a sworn statement by law enforcement that they believe that a person or area needs to be searched, and they need to search for certain things to build a case, a criminal case against this person or business. Judges will normally want something already showing that there's probable cause here. So they want to know that, okay, if they're going in here, there's a reason for them to do it other than the fact that they just want to do this and harass this person. They normally will want to see something, showing that there's a reason, a true reason, a reasonable search that's going to happen here. The Fourth Amendment protects against those unreasonable ones, those illegal ones. And they want to know that if they're signing off on it, that it is a reasonable search that has happened. Now, the Fourth Amendment states that it needs to be for specific persons, for specific items, those type of things. The warrants will lay out what they're looking for, what they're searching for, the area to which they're going to search. It'll lay out the reasons behind it. It'll have all those things within it. There are certain things that can happen that will cause the ability of law enforcement to step outside the warrant just a bit, but those are unique, and we'll talk about those also. But then you can also have a search based upon probable cause. A law enforcement officer pulls you over, you're speeding or whatever, they pull you over, they see an open container of alcohol in your car, they have probable cause to search your car. They smell a distinct smell that smells like marijuana, they can ask you to step out and claim probable cause to search. Your car matches a description of a car that was just seen leaving the scene of a crime, and especially if you match the description of the person, they're going to have probable cause to have you exit the vehicle, conduct their search, looking for anything that could tie you to that crime. And this also goes for you as a person, if that is the case in any of those little scenarios. Now, how does that apply to a business? A business, normally every search and seizure within a business will happen because of a warrant. Probable cause is not quite as easy for them to prove on an instant basis as it is to get a warrant and make sure they're covered. Why? Because most people that get pulled over on the street, they do not have a group of lawyers on retainer waiting to defend them. A business, a corporation, will normally have a set group of lawyers that do nothing but build their defense in case anything arises that they need to go to court for. So it's a matter of making sure that you're covering everything that you need to cover when you're trying to build a case from the prosecution side. From the defense side, you want to make sure that you have, if they issue you a warrant or they hand you a warrant, you want to make sure you understand everything on it. Do not impede their progress or their search. Just maintain your copy of that. Make sure that your attorneys have what they need, and keep note of anything that has changed, especially in a business. Keep note of anything that's damaged, anything that could be removed, because that could all be grounds for having evidence thrown out and those type of things if you're not guilty. Once a valid search warrant is issued, then they can search the area identified in the warrant for the named items or persons. If there's not a warrant, items can still be found, be admissible in evidence. If they're doing a search warrant and they go in looking for guns, or they go in looking for a person and there are drugs laid out across the whole house, they can seize those and charge anyone who is in that area with those. I know someone who's a married couple that one part of the couple went to prison because of a drug bust. The other one served probation because of one pill that was in an area where they were at. They can arrest anyone for anything in a common area. So it's, you got to be real careful who you associate with there and how you associate with them. When they come in to execute that warrant, anything that is a crime going on in their sight becomes something that they can act upon. That also carries into the reasons that they would not need a warrant in other cases also. The exceptions that fit into there, and here's the exceptions. Plain view is an exception. That's the one I was just talking about. This one, if a officer is in a store parking lot, they could just be doing a check. You know, in small towns like this one, the deputies will ride through the parking lots of different stores once they shut down. And they'll kind of just view in there. They may shine their light, whatever, just to kind of check things. If they see something going on, they can act upon it. The same goes for if they see, officer goes up to, they're going up to a pawn shop and they see stolen items or what they suspect to be stolen items. they can seize those through the pawn shop and get the information that goes with it. They witness a crime in process. Of course, they do not have to go through the whole process of trying to get a warrant to arrest someone or to search them once they do catch them. Destruction of evidence for them to stop somebody from doing that. The flushing of any type of item down a toilet would be a reason for them to go beyond, that would give them some cause to go check that area. They can seize whatever may be trying to be destroyed. If it's in an emergency circumstance, now, this is one Hollywood loves to build up and play up the whole, hey, I hear somebody, they don't have a warrant to get in. You got two officers standing there, they don't have a warrant to get in. One of them looks at the other one and says, hey, I hear somebody screaming in there. Me too. And they kick a door in. Well, there's actually a emergency or exigent circumstance that can happen, but there better be somebody in there who needed your help if you do that. If not, you're probably going to have to answer for that, and you're not going to have some happy prosecutors and judges in those cases for the most part. Consent, someone simply says, yes, you can search me, then they can. For their safety, officers, upon making an arrest, will search someone, normally a pat clothes search. They'll pat search them, over their clothes and, pockets. They'll have them pull out their pockets, those type of things. And then incident to a lawful arrest. Once someone is arrested and they're taken into custody, when they get to the jail or wherever they're the facility they're being taken to, they can be searched once again for weapons or contraband or anything along those lines to make sure for the safety of everyone involved. The Fifth Amendment takes us a little step further than that. So we're going to agree that the search that was conducted was a proper search. All the paperwork was in line. Everything was done. And now you have been arrested. They have you in the back of a patrol car. This is where you exercise the Fifth Amendment. You have the right to remain silent. Then be silent. All right. That is what that right is there for. This is also depending upon what you're charged with, where you can see that a grand jury would take place. Unless it's land or naval forces or in the militia, when the actual service in time of war or public danger. No one shall be subject to the same offense twice put in jeopardy of life or limb. If someone is found not guilty, it triggers the double jeopardy clause. Found not guilty, it triggers it. A hung jury doesn't necessarily trigger it. Any other way, it doesn't trigger it. Not guilty means they cannot be charged again for that exact same offense and for the exact same crime. So that is where that comes into play. You can't don't have to be a witness against yourself or not be deprived of life, liberty, or property without due process of law. And nor shall private property be taken for public use without just compensation. That is the eminent domain clause. If the government claims eminent domain over property, they have to have a just cause for why they're doing it, and they have to pay a just compensation. This is normally something slightly below what would be market value on property. The government's not going to pay you market value for anything, but it would be something that's a little bit below market value for the property in most cases. But that's a just compensation if they need to use it for a road going through or building, something that the government needs. There are certain tests they have to go through to prove they actually need that, and so that is when it comes to public use, they have to go through those steps. They're going to take that private property. This slide just kind of backs up what we were saying about these. The biggest one, the right to avoid self-incrimination. You have a right to be quiet, be quiet. It's just that simple. No matter if you're guilty or innocent, you have the right to be quiet, be quiet. Don't build anything or say anything, because sometimes in stressful situations, we'll say stuff that we do not even mean. It really is not anything that applies to anywhere, but it could be taken in the wrong way. So if you have the right to be quiet, just be quiet and let the procedure go in the way that it should. Sixth Amendment. This is one that has to do with the way that we conduct trials. In a criminal prosecution, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have a compulsory process for obtaining witnesses in his favor, and to have assistance of counsel for his defense. All right, so let's break this down real quick and then we'll move on past it. All right, so the Sixth Amendment entitles you to a speedy trial. Now, keep in mind these are rights. All right, so a speedy trial, real good for the prosecution, not normally very good for the defense. Most people waive the right to a speedy trial so they can build a proper defense. The right to a trial by jury, that is a right. You can decide that you want to have a trial that is called a bench trial, where the only person that listens is the judge and they make a decision. My thoughts on this, and it always will be this way. If I have to put my fate in the hands of someone, do I want 12 people or one person? Of those 12 people, the likelihood that every one of those 12 people woke up and the coffee maker was broke, they tripped over the dog trying to get out the door to go get coffee. When they finally got their coffee, they spilled it on their clothes they were going to wear that morning to the trial, had to go back home and change, and then go back through the whole process, and didn't get their coffee to start with and had to drink nasty old courthouse coffee when they got there. It's not likely all 12 of those. That one judge could have went through all that, and he's having a bad day. If your trial is by the bench, by that judge, he's having a bad day, the likelihood of you having a bad day with him is going to be very high. So trial by jury gives you a jury of what is considered your peers from the area that the crime happened, those type of things. So trial by jury seems to work a little bit better. It can be a public trial. You have the right to an attorney. Remember, that is a right also. If you decide you do not want to have an attorney, want to represent yourself, be what's considered a pro se litigant, not advised. Attorneys normally do not represent themselves. Attorneys have attorneys for cases where they have to go to trial, but you can do that. And then the right to confront witnesses. Maybe you don't have any witnesses on your behalf, or maybe you don't have anything to ask the witnesses for the prosecution, but you have a right to do that. And you have a right to have your own witnesses also that back up your side of things. Sixth Amendment is set up to ensure transparency in criminal proceedings. So the government cannot selectively prosecute dissidents or employ unfair tactics. Defendants are entitled to an attorney during any phase of criminal proceeding where there is a possibility of incarceration. Even if at the very beginning you turn down that attorney, you can get one assigned to you. It also means that if you can't afford one, of course, you can get one and the government pays for it. But you have that right to an attorney. Exercise those rights. In a business setting, you have all these same rights that apply. Exercise those rights. The Eighth Amendment, we don't go into much with this, but the Eighth Amendment does cover the excessive bail and anything to do with cruel and unusual punishment. Normally, businesses do not run into that. That's why I've removed it from the overall PowerPoint. Businesses normally do not have to deal with cruel and unusual punishment and things along the lines of excessive bail and those type of issues. In the criminal prosecution, it goes in order of an arrest, a booking, a formal notice of charges, which is normally your first appearance, preliminary hearing to determine probable cause, an indictment or information if it doesn't go to an indictment, an arraignment, and then the trial. At the arraignment, is when the judge will set the date for the trial to happen, and that is how that procedure normally happens. Very seldom does it change from that. So let's talk about the nature of crimes when it comes to corporations. The liability of a corporation is under certain circumstances. A corporation can be convicted of crimes and punished by fines. We do see fines being levied against corporations when they violate things such as fair trade, when they maybe will sell stock that they shouldn't have sold, those type of things. We also see it where corporations knowingly put out bad products. They knowingly participated in a fraud and those type of things. That's where businesses can be punished. But we also have crimes that happen against businesses. So let's look at a few of those. A white collar crime is a nonviolent crime involving deceit, corruption, or a breach of trust. The term white collar comes from almost everyone who ever worked in an office, uh, and most people still they wear a white shirt with a white collar on it. Or if it's from the 80s, probably a blue shirt with a god awful white collar and white cuffs. One of the worst things to come out of the 80s to me. But they did have those quite a bit, and you still see those around. Uh, but that is a white collar crime comes from the just the way that the most of the people who were convicted of those were dressed. Computer crime is one of the newer ones of those because computers as we see them now are really a kind of a recent thing within the last we'll say 30 years do we get to the point where we could have computer crimes, and more so in the last probably 15 years have we seen the ability of criminals to cause the type of damage they do by being able to get into computers and really and truly just wreak havoc in corporations, steal millions of dollars, people's identities, those type of things. As technology advances, the types of crimes that can committed with that technology will always advance also. One of the others is RICO. Most people have heard of RICO. Now, if you have a friend whose name is Rico, that's not who this is referring to, but RICO is a Racketeer Influenced and Corrupt Organizations Act designed to bring down the mob. This was designed to bring the mafia down uh, way back when it was created and has been used for that very little. The way RICO is set up and the reason it was so effective when it was used against the mob is that RICO builds upon an organization. And normally, how RICO will work is they will arrest 50 people at the bottom level, so many people mid, so many people at the top, and then some leader. They'll bring an indictment against everyone. And basically, what they want to do is fold each of those bigger sections on top of that smaller section until they can get to the person at top and bring criminal charges against them. One of the most recent RICO or prominent RICO trials, or never made it a trial, but one of the RICO cases was the case out of the state of Georgia against now President Trump when he was still former President Trump. The case that was built and never really came to fruition was a RICO case. They brought in, I believe, at some point there were, several dozen witnesses. By the time it was all said and done, they were around 19. That last time I looked at it, and I haven't bothered with it since the election started going the way they were going. Not really a lot of need, but it brought in a bunch of people who supposedly had access and knowledge of a crime committed, and the goal was to get those to turn state's evidence on the next one's up and the next one's up until they got to Mr. Trump, so they got to President Trump. That was the goal that they had set up there. and it was working. They had people who were turning state's evidence. Uh, it's used to those type of things. Now, more and more, RICO is used against businesses, not so much organized crime and those issues. It's used against businesses. 75% of the cases, and this is from a few years ago, but RICO, 75% of the RICO cases involve some type of business fraud. The reason being, businesses have that same structure. They have a CEO at the top, and then it just expands down. And you start getting those people at the bottom, they will start telling on the people at the top. That's the reason RICO works so well for that. Larceny is a trespassory taking and carrying away a personal property of another with the intent to deprive the victim permanently of the property. Businesses have this happen to them quite a bit. Embezzlement is when someone who is within the business will take something that they were in lawful possession of the property, but they will take it and convert it to their own use. So taking another's property by a person who was in lawful possession of the property. Unfortunately for you accounting students, accountants do this way more than they should. And you have people who, smaller businesses, the bookkeeper that just keeps the books back at the office will sometimes be the ones who do this. We had a rash, it was probably 15, 20 years ago now, of these happening in the small town I live in. Bookkeepers for these businesses were just committing embezzlement. There was like 3 or 4 of them in the local businesses. False pretenses of obtaining title to property of another by means of representation, one knows to be materially false, made with the intent to defraud. This can happen to businesses, especially to banks and those type of things. Someone will fraudulently try to obtain title to property. Someone has a mortgage out, a person will go in and assume that title to that land or that property. And when they do not have a legal claim to it, robbery is when we commit larceny with force or threat of force. All right, so that is what robbery will be. Burglary is normally going to include an entering into a building with the intent to commit a felony, and extortion, making threats to obtain money or property. We've all seen, different movies and things where someone's being extorted. Hollywood loves to use this as a way to, in their crime shows, when one person kills another person, it's because they were being extorted by that person. Extortion happens on small scale and on large scale in businesses quite a bit. We have bribery here that can be against a business or can be a business committing it. Bribery is one of those that business can commit just as well as it can be committed against them, offering money or property to a public official to influence the official's decision. There was just a former senator that was sentenced to, I believe, 11 years in prison because they were receiving bribes from businessmen and foreign nationals from Egypt. And I'm trying my best to remember. Menendez, I think, was the senator's name. I may be wrong, but I'm pretty sure that was the name. He was sentenced to 11 years just this past week in a case involving bribery to a public official from businessmen in New Jersey and from foreign nationals in the nation of Egypt. Forgery is someone who intentionally falsifies a document, signs their name to it, does so to defraud someone of an item of money or property or whatever, and in bad checks. Businesses do not suffer from this quite as much because there's not many people that write checks anymore. But at one time, it was one of the worst things that could happen to most grocery stores and retail establishments like a Walmart or Target or a place like that. Someone would write a bad check right before checks started really getting phased out. And there's still some that happen, but before checks started getting phased out as a common way of being used, a system had been invented that treated a check just like you using your card to pay. The money would come out instantly, and it stopped quite a bit of that type of crime happening. So if your business has been, it's like I'm fixing to start a commercial for an attorney here, but if your business has been charged with a crime or you're facing that, um, or as an individual, the defenses that we run into are can be that you are defending a person or property. Um, that's normally for if you've harmed someone, an assault case, a battery case, or even a murder case. Defense of person or property. Use a reasonable force to protect themselves or other individuals and their property, as can happen within a business. Duress, you were coerced into doing something by threat of serious bodily harm or harm to your family or those type of things. The only thing that does not uh, give you a defense against is murder. You have a mistake of fact. That's an honest, reasonable belief that the conduct was not criminal. Entrapment. Law enforcement induced you into committing the crime to be able to charge you with it is another way that you can defend yourself against it. And that covers criminal law. There's a real quick brief on criminal law, y'all. So make sure you're reading back through this, read through the chapter. Do not neglect reading the chapters uh, just because that you get a lecture with a PowerPoint and those type of things, because those questions that you a lot of times are not done properly on the quizzes, those essay questions, those come straight from the chapter. And by knowing the chapter and reading the chapter, you'll be able to answer those a little bit better and save yourself some time because you'll be able to recall it from memory. All right. So coming up later this week will be a little mini lecture on the case studies and those type of things once I finish grading those. Once again, case study 2, I've pushed the due date back a week. So you'll have a week to do that. It does put a crunch in there between that one and case study 3. Case study 2, case study 3 will be a week apart, but you'll be better armed and better prepared to do those case studies once we get through this first one. All right. So until next time, stay safe and study hard.